Your child was seriously injured in Iowa, and you want to do right by them, but the decisions you make in their personal injury case could determine their financial future forever.
Hi, I'm attorney Tim Summelroth of RSH Legal. For the past 27 years, my firm and I have been helping Iowans fight for the fair compensation that their injured children deserve. If your child has been seriously injured in Iowa and you want a free consultation with an attorney you can trust, give me a call at 319-895-1847. When your child is injured because of someone else's carelessness, you're facing one of the most important legal decisions of your family's life. I've seen the same devastating errors repeated by caring parents who simply didn't know what they didn't know. I'm going to reveal the 7 most costly mistakes that families make with child injury claims in Iowa and how to avoid them. Mistake number 1, blindly believing the insurance company's statements about legal deadlines. Let me start with the most dangerous trap that catches families every day. Insurance companies will send you official-looking letters about legal deadlines designed to mislead you into missing out on thousands of dollars. Now, here's a shocking example about how a national insurance company, one who claims to serve veterans, almost tricked a mother who was trying to do right by her injured child. A child was hurt in a car accident in Iowa, and like any parent, the mom wanted to make sure that the child's medical bills were covered. She got a letter from the other driver's insurance company saying that she had until her child's 19th birthday to file a claim for all damages from the accident. Seems fair, right? Wrong. If she had trusted that letter and waited, she could have missed out on reimbursement for over $10,000 in medical bills. Why? The letter left out a huge detail. In Iowa, parents only have 2 years from the accident to settle or file a lawsuit to recover medical costs for a minor child. After that, compensation for those medical bills from before the child turns 18 is lost forever. Only compensation for other damages like pain and suffering or future medical expenses can be sought until the child reaches age 19. Now, this misleading letter could have cost this family thousands. It shows a bigger problem. Insurance companies will often twist the truth to avoid paying what they owe. The mistake families make is trusting insurance company letters about legal deadlines without understanding the different types of damages have different time limits in Iowa. Mistake number 2, not understanding Iowa's age-based liability rules. Here's where child injury cases can get particularly tricky. Your child's exact age at the time of the injury can literally determine whether they receive full compensation or have their settlements slashed by tens of thousands of dollars. Under Iowa law, children 3 years old and younger cannot be assigned any fault whatsoever for their injuries. 0. None. But if your child is 4 or older, insurance companies can suddenly argue that they contributed to their own accident. This age difference can mean the difference between full compensation and having your child's settlement cut by 30, 40, even 50%. Same injuries, same circumstances, but 1 day of age difference could cost your family thousands of dollars. Insurance adjusters are specifically trained to check your child's birth date. They'll argue that your 4-year-old should have known to look both ways or knew better than to run into the street. But here's what they won't tell you. Even for children over 3, Iowa uses a special legal standard for what qualifies as fault. The question isn't what an adult would do, but what a reasonable child of the same age, intelligence, and experience would do in the same or similar situation. Iowa also has specific laws that place special duties on drivers when children are present. Iowa law states that when a driver sees a child on or near a roadway,
They must immediately come to a complete stop if necessary and take any precautions to avoid accident or injury.
this law specifically recognizes that children may act without care and suddenly and unexpectedly leave a place of safety. This means that drivers can't just rely on the typical defense of the child ran into the street. In Iowa, drivers are legally required to expect unpredictable behavior from children. The mistake that families make is accepting the insurance company's arguments instead of demanding they prove their case under Iowa's child-specific laws. Mistake number 3, not knowing what your child can actually recover. Here's something that will shock you about the compensation that your child can actually recover under Iowa law. Most parents think that injury settlements only cover medical bills and maybe maybe some pain and suffering. This limited thinking costs families enormous amounts of money. Iowa recognizes damage categories for children that many people overlook. For example, your child can recover for loss of earning capacity for their entire adult life, from age 18 to retirement. They could recover for future medical expenses that they'll likely need as adults. They can recover for loss of function of their body or their mind. When a child suffers serious injuries like brain injury, spinal cord damage, or permanent disability, the lifetime impact can reach millions of dollars. But insurance companies will focus only on immediate medical costs, hoping that families don't understand the full scope of what Iowa law allows children to recover. The mistake families make is thinking small instead of understanding that Iowa law recognizes that a child's injury can impact their entire lifetime earning potential, relationships, and quality of life. Mistake number 4, accepting settlement offers too early. Now, here's a critical mistake that costs families hundreds of thousands of dollars: settling too early before you understand the true scope of your child's injuries and their long-term impact. Insurance companies have one primary strategy when dealing with child injury cases:
settle fast, settle cheap.
they know the longer a case remains open, the more expensive it becomes as the full extent of injuries becomes clear. Children's brains and bodies are still developing, which means that injuries that seem minor initially can have devastating long-term consequences. A traumatic brain injury in a 5-year-old might not lead to learning disabilities until they're in middle school. A broken bone may cause growth problems that don't appear until adolescence. But insurance companies will pressure you to settle within weeks or months of the accident, before these long-term impacts become apparent. They'll focus only on immediate medical bills and claim that that's all your child deserves. Iowa law recognizes this problem, which is why children have until age 19 to pursue their claims for harms and losses that will last beyond childhood. The law understands that you can't properly evaluate a child's injuries until you see how the injury affects their development, education, and future potential. The mistake that families make is allowing insurance companies to pressure them into quick settlements before the full impact of their child's injuries becomes clear. Mistake number 5, falling for the $25,000 settlement trap. Now, here's a trick that insurance companies sometimes use against Iowa families, and most parents never see it coming. Under Iowa law, any settlement under $25,000 can be paid directly to the custodian of a child without court approval. Insurance companies sometimes exploit this by rushing to offer exactly $24,999, just $1 under the amount that would trigger a judge to have to sign off on the settlement. They'll tell you that it's quick and easy and avoids all the complicated court paperwork. What they're really just doing is avoiding the one thing that protects your child: having a judge review whether the settlement offer is actually fair. Here's how devastating this trap can be. Once you cross that $25,000 threshold, Iowa law requires either a conservatorship with court approval or a structured settlement. This means that a judge will examine the settlement amount, your child's injuries, and the long-term impact. Insurance companies hate this oversight because they can't lowball you while a judge is watching. The mistake is thinking that avoiding court oversight helps your family. In reality, the need for a judge's approval of a child's settlement can be your most powerful protection against insurance company tricks. Mistake number 6, not exploring. Now, here's a mistake that could cost your child thousands of dollars over their lifetime. And insurance companies will never tell you about it unless you specifically ask. Most families accept lump sum settlements for their children without ever hearing about structured settlements. But structured settlements can provide guaranteed income for your child for a set period of time instead of one single payment that they get when they turn 18. Think about this choice. Would you rather have your child receive $200,000 when they turn 18 or $2,000 per month for life starting at age 25? The lifetime value of those monthly payments could exceed $1 million, but it costs the insurance company roughly the same. Insurance companies prefer lump sum settlements because it allows the company to close their books on your claim forever. Once they pay that settlement, they're done. The mistake that families make is not knowing that this structured settlement option exists, so they accept a lump sum payment when a structured settlement may better serve their child's long-term financial needs. Mistake number 7, not understanding Iowa's unique medical malpractice deadlines for children. If your child was injured by medical malpractice, Iowa has special timing rules that are completely different from regular injury cases, and getting these wrong could destroy your child's future legal rights. Here's what makes Iowa different. For children who were under the age of 8 when the malpractice happened, you have until the child's 10th birthday or 2 years from when you discovered the injury, whichever gives you more time. This extended deadline exists because medical injuries in young children often don't show up for years. But here's the critical trap. Iowa also has an absolute 6-year deadline to act from when the malpractice actually occurred. This means that even with the special rules for young children, you can't wait forever. The only exception is if a foreign object like a surgical tool was left inside your child's body. For children who were 8 or older when injured by medical malpractice, the standard 2-year deadline applies. But again, never more than 6 years from the actual malpractice. If your child has been injured here in Iowa and you would like to set up a free consultation with an experienced attorney who will fight for what they deserve, please call us today at 319-895-1847. Our conversation is confidential, it costs you nothing, and could potentially get you the biggest possible settlement for your child's case. Now, if you found this video helpful, subscribe to this channel and make sure you watch this next video.